(2019-80) Frank McElvey.
Good morning.
Good morning. Just a second, I've got to pull your case up. Mr. McElvey, can you hear the court all right?
I can hear you pretty good. It's not real good, but I can hear you.
All right. This matter is for arraignment today on charges of possession of drug paraphernalia, Class B felony, possession of drug paraphernalia, Class D felony, possession with purpose to deliver, Class A felony, simultaneous possession of drugs and firearms, a Class Y felony, and possession of a firearm by a certain person, a Class D felony. Mr. Cooper, you've been appointed to represent the defendant?
We have been, Your Honor. I visited with Mr. McElvey, and I would enter a plea of not guilty to all charges.
And a plea of not guilty is entered on the record. This matter is set down by scheduling order for a trial during the week of August 19th of 2019, and it'll be set for a reappearance hearing on May 30th. Are there any other matters to be addressed at this time?
Yes, Your Honor. Your Honor, 2 weeks ago when he appeared in front of you, an OR bond was given to him, conditioned upon him passing a drug test. Your Honor, his income is totally Social Security. His wife,
Right.
Monica, is here in the courtroom today. She's totally dependent upon him. They live at 150 County Road 27 in Mountain Home. I've talked to the state. I would like to propose what we had talked about 2 weeks ago, and that is that he be released on an OR bond and live at the address that I just gave the court and condition upon him passing a drug test. All of this, Mr. McElvey and I talked about yesterday.
Well, the court is somewhat, the court's concern is that Mr. McElvey, as far as I know, was not truthful with me in terms of his drug use, and that's the issue from this court's point of view. But I understand his limited resources, so the courts will approve the OR release subject to successfully passing a drug test and make it a condition of that OR release that he submit to regular and random drug testing at least on Mondays and Fridays of each week. We're not seeing him in court again until May, the end of May, and so if he's released, the court also expects him to get in to see the not only to appear for drug testing as ordered, but also to get in to see his attorney and be responsible for that. So, anything else?
Yes, Your Honor. One of the concerns the state also has with this individual is his apparent lack of having a driver's license. And the state would request that he not be allowed to operate a motor vehicle of any kind. I know he's not supposed to, but he would be ordered not to operate a vehicle of any kind until he can get a valid driver's license and have valid liability insurance. He's been cited for that. I didn't count them, but it appears to be probably some 10 plus times. And I have concern that he would be involved in an accident while using methamphetamine and harm someone, Your Honor.
Mr. Cooper, you want to address that issue?
Your Honor,
Have you discussed that with him?
I did not, Your Honor. I was not aware that he didn't have a valid driver's license. Obviously, if he does not have a valid driver's license, then he shouldn't be driving.
We don't disagree. The problem is he doesn't see it that way.
Well, if that's a condition of his bond, if he doesn't have a valid DL, then I certainly would not object to that being a condition of his bond.
Well, Mr. McAway, you need to understand that the court is agreeing to the OR release that you, but it is subject to you being, you have to pass a drug test and continue to pass drug tests while you're out. The court also is going to expect you to fully comply with the law while you're out. Any violation of the law would be grounds for having your bond revoked, your OR release revoked, and that includes you have to abide by the laws with respect to having a driver's license before you can drive a vehicle. So that. I hope that's understood. Your next appearance in court is May 30th. That's the next time you're going to be in this courtroom, but the court would emphasize to you it is your obligation to get to and see your attorney. You're getting provided an attorney by the state, paid by the state. It's your obligation to get in to see him, and I'm ordering you to do that. So please understand that you have to make arrangements, call the public defender's office, make an appointment, and then get there. So all of those are your obligations. Do you understand that?
All right, yes, sir.
All right. You may be excused at this time.
Okay, so I'm coming hearing a lot of static in the phone, so they're saying that they're gonna allow me to go. Is that what's going on in that stuff?
That's right. Yes, sir. I have approved your OR release, but it's conditioned on those things that I just said. That you have to, first you're going to have to pass a drug test. Secondly, you're going to be subject to you're going to have to get into the probation office and be drug tested twice a week on Mondays and Fridays. And the court's going to expect you to abide by all the laws, including you're going to be, you cannot drive a motor vehicle without having a valid driver's license. All right.
Thank you, honey.
All right. You may be excused.
Thank you.
Two 2019-60, State of Arkansas versus Nick Garbinski. Mr. Garbinski, what's the nature of your self-employment?
I do drywall. I'm doing some remodels in Jordan area.
All right. Based on the affidavit, the court's going to make the appointment of the public defender's office to represent Mr. Garbinski.
I filled out an application last week, sent it over.
Right. That's what I was reviewing.
Oh, okay. Thank you.
So I'm making the appointment of the public defender's office.
Okay, thank you.
This case is also down for a reappearance. Today is a review hearing date. It's down for reappearance on May 16th with a trial date set for the week of August 19th. Are there any issues to take up today?
You know, I am not familiar with Mr. Garbinski's case. If he has any issue, it'd be a bond issue. If he wants to speak on that, then I would ask permission from the court to allow him to speak on any issues.
That'll be fine.
I would, if I could, Bonnie, I would appreciate it, because I do have 2 jobs going in Jordan right now that are remodels that people live in the house. I also have new construction going on, which I'm sure they probably moved on with that already. I probably lost that job. But I do have 2 remodels that I'm in the middle of that I need to get finished up. I mean, I'm not going anywhere. I've been trying to get stuff taken care of, so I can give money and get this taken care of.
You know, Judge
I mean, the
Putnam,
reason I got pulled over the last time was for the suspended license, and I wasn't even out 36 hours yet. And I'd worked 20 of or 19 of those hours that I was out.
Judge Putnam set him on his revocation for a $3,000 cash bond. The reason that happened is he's on a revocation. We get him, he turns out he has another revocation, so that's why we've asked for the $3,000 cash bond on Mr. Grabinski. The court may remember the last time he appeared, he was the one who said he was discombobulated.
Yeah, look, my daughter was in a mental institution, and I couldn't be there for her, and I was trying to be there, and I mean, I got a lot of family stuff going on. When I said discombobulated, it was because of my family issues, not because of anything else.
Okay.
I mean, if you guys recall, my daughter was the one that was with the.
This,
But
but
you
you
never-
do have a revocation, you have a revocation set in front of Judge Putman,
Okay.
do you?
I'm not. Every time I come in here, I just get told to come back the next court date. So I'm trying to find out what's going on myself, Your Honor. I don't know. And it makes it even harder sitting here not knowing what's going on.
Now, it's set for revocation hearing next week, so he's not gonna be there long.
All right. But this reflects that he's got a $3,000 cash bond on this case, based on the information charged in this case. But I assume that's,
That's because we had him, he leaves and he reoffends, and so we've been asking that to happen, Your Honor, to assure that someone who's got immediately out on bond, they don't do it again.
I got pulled over coming home from work, and they said they found a bag of meth in my truck. There was not a bag of meth in my truck, Your Honor, but I just got my truck back the day before and went to work, and then I get pulled over for driving on a suspended license, and they say they found a bag of meth in my truck, which I didn't have meth in my truck. I mean, I asked for a drug test as soon as I got here because it was a bogus charge. I mean, I feel like I'm getting taken here right now, really. And I would like to ask to have the opportunity to prove that, I mean, that I'm not what I'm being made out to be right
well,
now.
Mr. Garinsky, you're going to have that opportunity because apparently your revocation case is set for hearing a week from today in front of Judge Putman. That,
Is there
I'm
any way I
not
can
the
have all
judge,
this
I'm not the
and
judge
deal
on
with it all
that
at one
case,
time?
so.
I'm sorry, do what?
I said, I'm not the judge on that case, so that you'll have your hearing and your chance to address those issues in front of Judge Putman. And apparently,
Okay.
he's the one who set this bond, a $3,000 cash bond.
Okay.
Mr. Grabinski, Mr. Pastings will be representing you on the revocation. And,
Okay.
we will let him know. He'll be here later in the day, and I'm sure he'll come down to the jail and visit with you prior to the revocation hearing next week.
Okay.
My advice to you, sir, is not to say anything more today. Talk to Mr. Pastings and let him handle this matter, let him handle the talking for you, okay?
Okay, thank you.
All right, you may be excused.
Thank you, John.
Call 2018-406, State of Arkansas versus Page, Leanne Parrott. Ms. Parrott, you are appearing at this time for purposes of changing your plea on charges against you, is that correct?
Yes, sir.
And this change of plea is brought about by an agreement that's been worked out on your behalf by your attorney, Mr. Cooper, is
Yes,
that
sir.
correct?
Yes, sir.
Have you had a chance to talk to Mr. Cooper about the terms of the agreement and the punishment you're to receive?
Yes, sir.
You feel you understand what the agreement is?
Yes, sir.
Are you satisfied with the advice and the representation you had from Mr. Cooper?
Yes, sir.
On the charges against you of possession of controlled substance, marijuana, Class A misdemeanor, and possession of drug paraphernalia for the use of methamphetamine, a Class D felony, on those charges, how do you now plead?
Guilty.
You're in your plea of guilty pursuant to the agreement we've been discussing. That agreement is set out in writing in the document I'm holding up called a plea statement. Have you read through this plea statement?
Yes, sir.
And do you feel you understand and signed it? Have you signed it?
Yes, sir.
You feel you understand what's set out in it?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing.
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty.
Yes, sir.
When you plead guilty, you give up your right to a jury trial. You also give up your right to have an attorney represent you and assist you throughout that trial. You also give up your right to confront witnesses that would appear and testify against you at trial, and you give up your right to appeal. All of those are rights you're giving up by pleading guilty. Do you understand that?
Yes, sir.
And understanding what rights you're giving up, are you still willing to plead guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into this plea?
No, sir.
In pleading guilty, are you admitting that on or about September 11th of 2018 here in Mountain Home in Baxter County, in a traffic stop that you had in your possession both a quantity of marijuana and paraphernalia related to the use of methamphetamine?
Yes, sir.
Specifically, I guess, that there was a syringe and certain plastic baggies, and then you had also the marijuana and some paraphernalia related to it as well. Is
Yes,
that
sir.
all right? Based on those statements, the court's going to find the defendant has freely and voluntarily entered her plea of guilty, done so after consulting an attorney, and has admitted that her actions that constitute the basis of the crime. On that basis, the court at this time accepts the defendant's plea and finds the defendant to be guilty of the offenses of possession of a controlled substance, marijuana, possession of drug paraphernalia for the use of ingestion, for the use or ingestion of methamphetamine. Having adjudged the defendant so guilty, the court will sentence the defendant in accordance with the agreement on the Class A misdemeanor. The court is sentencing the defendant to 1 year of supervised probation, subject to the standard terms and conditions of probation of this court for a misdemeanor. And on the felony offense, is sentencing her to 4 years of supervised probation, subject to the standard terms and conditions of probation of this court. Those sentences will run concurrent with each other, and the defendant will be ordered to pay costs of $200, a fine of $2,000, a statutory DNA fine of $250, a booking administration fee of $20, a public defender fees of $200, and a drug crime assessment of $125. All of these amounts will be due and payable as a term and condition of the defendant's probation, with payments to be made in regular monthly installments of at least $100, with the first payment due within 60 days of this date, and to continue each month thereafter until the whole amount is paid in full. That'll be the order of the court. The defendant has signed an acknowledgment indicating that she has read, understands, and will comply with the written terms and conditions of her probation. Those written terms and conditions of probation are attached to the plea statement that the court has signed them as well. The court by signing them, is making an order of the court that you have to comply with those written terms and conditions of probation. I'm going to direct at this time that you meet with a probation officer and get set up on probation. You may be excused.
Thank you.
We had 1496 Danielle Astry. Is that?
Yes, Your Honor.
That's the next one.
Your Honor, may I announce what the agreement is on this?
Yes, you may.
Your Honor, this is being amended to a contempt. She will receive 120 days in the Baxter County Jail, credit for time served.
That is correct, Your Honor.
Ms. Astry, you're appearing before the court at this time on a charge of a petition to revoke a suspended sentence. That petition was filed September of 2017, and it alleges that you were in violation of the terms and conditions of your probation based on actions of yours in August of 2017, starting with failure to report to your supervising officer, and then subsequent to that, you discovered you no longer lived at the residence that was originally or officially listed as your residency, and then the no contact, and you were directed that on or about August 28th it was determined you were evading supervision, and you failed to pay your supervision fees and had an arrearage of over $260. But those are the allegations contained in the original petition. On those allegations, this matter was, how do you now plead?
Guilty, Your Honor.
You're admitting that each of those allegations?
Yes, sir.
Okay. You're entering this plea of guilty pursuant to the agreement that's been worked out for you by your attorney, Mr. Cooper?
Yes, sir.
And have you discussed the terms of the agreement and the punishment you're to receive with Mr. Cooper?
Yes, sir.
Do you feel you understand what the agreement is?
Yes, Your Honor.
Are you satisfied with the advice and the representation you've had from Mr. Cooper?
Yes, Your Honor.
As you enter this plea of guilty, are you doing so with a full understanding of the nature of the charges against you and the full range of penalties you're facing?
Yes, Your Honor.
Are you doing so with a full understanding of what rights you give up?
Yes, Your Honor.
When you, in a revocation case, you don't have a right to a jury trial, but you do have a right to a hearing in court, what I call a due process hearing in court. At that hearing, you'd be entitled to, at that hearing, the state would have the burden of proving that you violated the terms and conditions of your probation. At that hearing, you'd be entitled to call witnesses and have an attorney represent you throughout the trial process. At that hearing, you'd be entitled to confront witnesses that appeared and testified against you, and you would have a right to appeal. All of those are rights you're giving up by pleading guilty. Do you understand that?
Yes, Your Honor. It was completely my fault. I did evade it. Everything's true. It was completely on me and nobody else's fault but mine.
And if you enter this plea, you then understand you're still willing to, even understanding what rights you're giving up, you're still willing to
Yes,
enter
Your
this
Honor.
plea. Are you pleading guilty here today freely and voluntarily?
Yes, Your Honor.
Has anybody in any form or fashion forced you into this plea?
No, Your Honor.
Based on your statements here in open court today, then the court is going to find that the defendant has freely and voluntarily entered her plea, done so after consulting an attorney, and is admitted to her actions that constitute the violations of her probation. On that basis, the court accepts her plea and finds her to be in violation of the terms and conditions of probation. In accordance with the agreement in this matter, the court is sentencing her to 120 days, is revoking 120 days of her sentence and giving her credit for time already served. That will be the order of the court.
Okay.
You may be excused.
Thank you, Your Honor.
You need to understand that you're still on probation.
Yes,
once
sir.
you're
I do
released.
understand that.
And
Yes.
you need to report.
To report from the jail as soon as I get out, straight to my PO.
That's
Yes.
correct. You may be excused.
Thank you.